All right. Good afternoon, everybody. Thank you for joining us for Saul Ewing, Arnstein, and Lear's webinar series. This is the first webinar in our CLA series entitled Key Legal Considerations for Businesses Reopening and Rebounding. Today's program is going to focus on labor employment and privacy considerations. My name is Sandy Bilas. I'm a partner in our Philadelphia office, and I'm the vice chair of our cybersecurity and privacy group. I'm going to be covering the privacy aspect of the discussion, while my colleagues Henry Platt and Carolyn Pellegrini are going to be handling more of the labor and employment aspects. Before we start, I wanted to make a few housekeeping announcements. We do have a Q&A ability here. That you can see it down at the bottom of your screen if you're on Zoom. Questions can be submitted through the Q&A tool. And while we are going to do our best to answer all questions, if we run out of time, we will try to follow up individually with people through email. Today's program has been approved for CLE credit in both Pennsylvania and New Jersey. We hope to be able to get accreditation for other states in the firm's footprint for the remainder of the webinar series. To verify your participation at two separate points during this webinar, we're going to display and verbally announce CLE codes that you have to record and report back to us within a survey that you'll receive through email following this program. Once we receive your survey response, we can send you your certificate of attendance. So make sure you pay attention and listen to those CLE codes. Finally, a legal disclaimer, because we're lawyers. The provision and receipt of the information in this presentation is not legal advice, does not create a lawyer-client relationship, and should not be acted on without seeking professional counsel who have been informed of the specific facts. So given that, I'm going to turn it over to Carolyn to take us away. Carolyn.
Thanks so much, Sandy. Welcome, everyone. I have a slide up here that just kind of gives you a brief overview of where we're going to go today in our presentation. We're going to start with health and safety planning. There, we're going to talk about the sorts of things that everyone needs to be thinking about and the plans that we need to be putting in place before everyone comes back to the office or whatever work environment it is that you have. Then we're going to move on to employment policies. These are going to be policies that you either need to draft to address the new normal, or policies that you're going to need to revisit that are already in place, but perhaps need a little bit revamping since the coronavirus has hit. We're also then going to talk with Sandy about privacy concerns. There is a lot of information out there about testing employees or taking people's temperatures, things like that. All of that is information that you're now going to hold that you wouldn't normally hold, and Sandy's going to talk to us about what we can and can't do with that information and how to keep it safe. Then we're going to talk to Henry about employees who resist the return to work. So after you put all of your plans in place, you have all of your policies updated, and you say, come on back. The employees say, no, thank you, for whatever reason. Henry is going to give us some information about how to handle those situations with some very specific examples. So we're going to start with the health and safety planning. Again, this is going to be one of those things that we are doing before people start coming back to the office. And the question is going to be, where do we start? There's a lot of information out there, obviously, about the coronavirus. Who do we listen to? Who do we need to keep in mind when we're figuring out how we're going to come back to work effectively? So one of the things that we're going to have to take into account, obviously, is government orders. What are your governors saying? What are your county officials saying? Those sorts of things. Public health. What is your local health department saying? What are the orders that are coming out about that? And then also one that doesn't necessarily come to mind, but is going to be very important for people or for employers who don't own the facility, is going to be landlord requirements. If you are a tenant in a building, what is it that your landlord is putting in place? What is the building owner doing, and what are they requiring of their tenants? So those are the things that are all going to go into our bucket in determining how are we going to return to work and how are we going to do so safely. So we talked about governmental orders, and then we also have all of our alphabet soup of different organizations, different agencies that are providing information about the coronavirus itself, proper responses to the coronavirus, what potential employer liability is related to the coronavirus. These are all places where we're going to have to look and see what it is that they're saying to gather that information, synthesize it, and get a plan in place to combat. So obviously the World Health Organization, the National Institutes of Health, and the Centers for Disease Control are kind of a broad umbrella, right? They are the agencies, they are the organizations that are providing that high level information about the coronavirus. How does it spread? What is it that we should be doing? How are we going to keep it from transmitting as quickly as it has in the past? So we have those three. The Centers for Disease Control, I just want to touch on really quickly because they have put out some really interesting specific informational guidance about how we are going to return to work. And I just wanted to touch on that briefly. They provided a considerable amount of information. It's about 60 pages. And it includes things about like what sort of mask is going to qualify as a mask or is going to be good enough to stop the spread of disease. You know, they have some of that very specific information that is going to be helpful when you're putting your plan in place about how to return to work and how to reopen. I'm going to kick it to Henry really quickly to talk about the OSHA regulations and what exactly they're saying on their end. Henry.
Thanks, Caroline. Hello, everybody. Hope everybody's doing well. As far as OSHA goes, aside from general duty to keep a safe workplace, a particular note that a lot of people sort of missed, it sort of happened on a Friday, I think. The OSHA on May 19th issued a new revised interim guidance about whether or not a coronavirus sickness in the workplace is a recordable illness that the an employer needs to write down and investigate. And the answer is yes, employers do. So if someone's sick, you have to record it if it's confirmed to be coronavirus, so an actual doctor confirms it, and that it's confirmed to be work-related. Now, so the OSHA has said that employers have an obligation to figure out whether this person in your workplace has coronavirus, whether they've gotten it in the workplace. And there's a bunch of standards that they sort of put forth in there, but the general theme of the whole thing is that OSHA understands that employers are actually pretty ill-equipped to do that sort of investigation. Employers have limited resources. So they have a bunch of standards that you should look to. And if the OSHA has said that if they're in their discretion, they will just basically try to see if an employer made a good faith effort to do a reasonable investigation. You know, basically, if you have an assembly line and 10 people next to each other came down with it, it's probably a pretty good chance that it came at the workplace. If it's an isolated case and nobody else has it in the workplace, it's probably not. And that's about the level of the investigation, but it's worth taking a look at if you have any questions. Carolyn?
Great, thanks, Henry. And then the last thing, and Henry's going to speak to this more when we get to the people who are resisting return to work, is the Equal Employment Opportunity Commission. The AEOC has put guidance out there about whether or not the coronavirus is a disability. They have talked about whether accommodations need to be made for people who have an underlying condition that may be more susceptible to the coronavirus. So we're going to get into that a little bit later with Henry as well. But those are the organizations, you know, that are nationally or worldwide as the World Health Organization that we need to be looking to start gathering information about how employers are going to open safely and allow employees to return to work. So orders and guidance, really quickly, I just want to draw people's attention to the CLE reporting code on this. For those of you that are just listening, the code is pound 567321. So governor's orders, in many states, the governors are, in charge. They're the ones who are making the determination statewide as to what people are supposed to be doing. They are taking their own cues from the numbers of coronavirus cases, whether or not that decrease has come through. But there are also the local orders. And, we can't emphasize enough the importance of looking to those local orders in addition to the governor's orders. So those local orders may be coming through mayor's offices. They may be coming from the local health departments. I know in some states, particularly states like Maryland or other states that have coasts, there is a big push to open the beaches. Due to Memorial Day just passing, everybody wants to get to the beach, and there are certain cases in which some county executives are saying, yep, we're going to open, and others are saying, no, we're not going to do that. So those are also people that you really need to be watching what's coming out of those offices so that you can make sure that you're in compliance with all of the rules and regulations. Most of those orders that are coming out of county level government also have a lot of restrictions that are associated with them, things like masks, social distancing. Those are things that you're going to have to get your arms around before you can determine whether or not you can bring people back to work, and whether or not, or how you bring people back to work if you determine that you can. Two other places that are very helpful. One is industry associations. There are certain industry associations that have put out guidance. Things like the National Restaurant Association, they have put out a lot of great information that is very specific to the restaurant industry. It speaks to all different employees within the restaurant industry, whether it be back of the house, front of the house, and how all of that is going to work in the best way possible to protect people. I know that there's also a national multifamily housing. They have a lot of information out. So depending on what industry you're in, please look to your industry associations, because there's a good chance that they may have some really important information for you, or at least some great ideas about how to make things work practically. Finally, just a plug for ourselves. Saul Ewing does have a great employer checklist. It's available on the website. We're happy also to just send a link to anybody who wants to check that out. There's some really great information there about things that everyone needs to be thinking about when they're reopening facilities, reopening workplaces, whether you have, people who are going out into the field as salespeople, or whether you have an office environment. There's some great information there that can really get people started on getting the plan in place on how to reopen effectively. So I think the first thing that people think of when you think of reopening effectively and doing it in a safe way is cleaning and sanitizing. So the first thing that I want to touch on here is to go back to the slide that we had previously with the funnel, and it said, what are your landlord requirements? So if you are a tenant in a building, in an office environment, what I would say is that this is a really great time to reach out to the building owner or to whoever the management company of your building is. Because when you're thinking about cleaning and sanitizing the facilities in order to bring people back, there's a really good chance that your management company is on top of that already. And what you need to do is to think through what your plan of reopening is going to be in conjunction with what your management company has already put in place. Additionally, your management company may have certain requirements for you. And so you would want to know about those as well. But to the extent that, your management company engages the cleaning service for you, they may have already spoken to them, but if you engage your own cleaning service, it's going to be important to know what the restrictions and the requirements are of your building management in order to get everybody on the same page. So when you speak to a cleaning service, which something that you should certainly do sooner rather than later. In many places, everything in one county is going to reopen at once. Everybody's going to try to be getting on a cleaning service list. Everybody's going to be trying to make that appointment. I think that this is one of those things that it's the sooner the better. Contact someone, cleaning service, to get yourself on the list so that you can get it done in a timely manner and you can bring employees back when you need to. But when you contact them, make sure that they are undertaking cleaning in accordance with the current CDC recommendations. You know, a lot of cleaning services will help you establish cleaning and sanitizing stations. You know, there's all this information out there about what hand sanitizer you should be using. The CDC has all the information about that. It's 70% alcohol. Again, that's a place where you want to go and gather the information so that you can speak intelligently on it when you contact your cleaning service. And then talk to your cleaning service also about the frequency with which they're going to be cleaning. In most office environments, you know, they come by once a day to empty the trash or dust or whatever the case may be. To the extent that you're going to need additional cleaning assistance, you're going to have to work that out with your cleaning service. Also along the lines of cleaning and sanitizing is creating and displaying signage. Please don't reinvent the wheel here. There's a lot of great signage out there that can just be printed out, laminated, and put on the wall where it needs to go. You don't have to be an art major to get this done. Just Google it, print it, and put it up. You know, that signage should be reminding people of things, of everything from please practice good hygiene and wash your hands, please cover your mouth when you cough or sneeze, stay 6 feet away from people. Those are all things that we need to constantly remind people of. You would think that it's become second nature in this environment, but if you watch the news, you can also see thousands of people on a beach together that are very close together. So we need to be reminding people of this just constantly. And then determining the responsibility for more frequent cleaning. You know, in the office environment where you have people who are in and out of common spaces, a lobby, or people go up and down stairs that have a banister, you know, think of all those high touch surfaces and how frequently we need to clean those throughout the day. Who's going to be responsible for that cleaning? Where are the supplies for that cleaning going to come from? If there's a supply shortage, who's going to be in charge of figuring out what to do in that situation? Those are all things that we really need to be keeping in mind when we're deciding how we're going to effectively reopen. Oh, I need to go back. So also the social distancing plan. You know, I was telling Sandy and Henry that when I was putting together this slide, I kind of thought, okay, well, what is my normal routine when I'm at the office, right? So you go to the office, it's not necessarily in order here, but it's early, I need coffee. How many people do I run into on the way to get coffee? Probably 6, depending on what time I get there. So you have to be thinking about the times that you're in the office. When do you run into people? When do you cross paths with people? When do you touch something that someone has just touched? And so these are all the different spots that I came up with in my regular work routine where you're thinking, okay, how are we going to deal with this? You know, personally, my office is set up in a circle. So traffic flow, all right, well, you only go one way around the circle. And if you miss your spot, I'm sorry, you're gonna have to keep going. But that keeps people from running into each other. It keeps people from getting too close, from not abiding by those social distancing guidelines. The elevator use, you know, this is certainly something you want to talk to your landlord or building manager about. How many people are going to be allowed in the elevator? Who is wiping down those buttons on a regular basis? The refrigerator, you know, that goes along with the coffee machine. Bathrooms is one of those places where you might need an extra couple of wipe downs throughout the day. Conference rooms, even if you're only meeting with one person, do we need to set up a conference room so we can stay an appropriate distance apart from each other? Staggered work schedules is becoming very much the new norm when it's possible, so that only X number of people can be in the office at any given time. You know, I've heard a lot about the 25% capacity number. So just think of all of the people that you work with, and then only 25% can be there at any given time. Sign up sheets to make sure people aren't just wandering in. And then the floor markings, that goes with the signage, you know, the constant reminder that you should not be any closer than 6 feet to another person. All things that you need to think of when you're thinking about how to reopen properly. So I also wanted to talk about a communications plan. So as much as we can put this plan in place on how to reopen appropriately, and we can get those sign-up sheets and that signage together, that's only going to help us to the extent that people are aware of it and are comforted by it. So you need to have a plan of how you're going to communicate this to your employees. So we're going to talk more about training later, but I do want to mention it here as well, is how are you going to train employees about these new policies, these new requirements? You need to tell them about the safety measures that you're taking. Again, this is one of the situations in which you're trying to make them as comfortable to come back to the work environment as possible, and showing them that, look, it is safe for you to do so. And how are you going to handle positive tests? A question is always going to come from employees. Okay, well, if my, you know, next door office neighbor ends up with a positive test, or if my partner, when we go out to do some sort of work at someone's house, if they test positive, what is going to happen? What's your plan? It's important to have those plans in place. So positive tests, just really quickly, there are a couple of different plans I just want to touch on. You know, the first thing that I would say is contact your local health department. Ask your local health department what exactly they are recommending that you do. You know, that's a really great way to get a baseline of what you should be doing. Sandy's going to talk about privacy later, but again, confidentiality in this case. Can you tell other employees, you know, John Doe came down with a positive case and you talked to him, so now we're going to, you know, sequester you or quarantine you for 14 days. You shouldn't be using employees' names to the extent that other people can figure it out. That might happen, but you shouldn't be using employees' names, but you do have a duty to kind of figure out who they talk to. Do that, you know, low-level contact tracing, that sort of thing. That's a really great way to deal with those positive tests. Vendors, when I say that you should have a communication plan with your vendor, I think that's a two-way street. You need to let your vendors know what you are doing to keep your employees safe and what your expectations are of the vendors when they're on your work site or in your workspace. And then I also think that you need to hear that from them as well. What is it that they are doing? What is it that they expect you to do in order to keep them safe as well? And then modified schedules. If you have vendors who come at noon to restock the snack machine, when there are a lot of people who might be eating lunch in that same area, is there a better time for them to come when they'll have less contact with people? So maybe modifying their schedules. These are all just things that seem small, but can really help reduce that risk of transmission and also help your employees feel more comfortable in the workplace. And then clients and customers. I don't have a lot here because it's really going to depend on what your industry is. If you're going into other people's homes, I think that there is a very large plan that you need to be putting in place. Whereas if you're someone like us, if you're a law firm and you don't necessarily have to meet with a client immediately face to face, that's going to be a little bit reduced. So I think you have to look at exactly what your physical exposure is to clients at this point and figure out a plan not only that will keep people safe, but also one that's practical and workable. If you come up with a plan that is too complicated or that people simply aren't going to follow, that's where you're going to really end up in trouble. So I want to touch also on employment policies. So we talked about, you know, getting that plan in place, sanitizing, cleaning everything, bringing people, how are we going to bring people back? But we also need to set the expectations for employees who are coming back. And how are we going to do that? So when employees are coming back, one of the questions that we've gotten a lot is, what can I say? What can I say to employees? What can I do to know that they are not someone who, has active symptoms of the virus and is just trying to come back to work to get out of the house and away from their family? What you can do are these things. And as I said previously, the EEOC has put out a decent amount of guidance about what you can and can't do. And this is from the EEOC, right? So what can you do to make sure people who are coming back are not infected, or at least you're doing your due diligence? So you can ask employees if they're experiencing symptoms of the virus, okay? I know that we tell employers a lot, don't ask people about their health because that's not a road we want to go down. In this case, it's definitely a road we want to go down. You can take employees' temperatures. Normally, you cannot do that. In this circumstance, you certainly can. That's often referred to, or it falls within the category of a medical examination. Here, what the EEOC has said is that this virus is a direct threat, therefore you can administer medical examinations to make sure that people are not a direct threat. You can require employees with symptoms to stay home. Think about whether, if you're going to require that people stay home, are you going to pay them? Are you not going to pay them? Are you going to make them take PTO? Things to think through. Requiring returning employees to provide fitness for duty certification. These are folks, this refers specifically to folks who have had positive tests or have extreme symptoms. Getting that note from the doctor that says, yes, this person can come back to the workplace is certainly an absolutely legal thing for you to be asking for, and we would recommend that you do ask for that. And then test employees. Obviously, we've heard a lot about tests and their availability and how accurate they are, but to the extent that tests are available, that is certainly something that you can do. You can test employees for the virus. So specifically talking about employment policies. So the employment policies that I have on the left side of the screen, those are policies that you probably don't already have in place, okay? That you're going to need to draft. These are things that are new. Teleworking isn't necessarily new for some of you, but for most, it is going to be new. And then on the right, we have policies that we're really going to have to take a look at and see how we need to revise them in the wake of the coronavirus. So let's start with the drafting piece, testing and screening. How is it that you are going to implement your testing and screening program, and how are you going to articulate that to your employees? Employment policies are always about making your employees aware of what the expectations are. So when you're drafting your testing and screening policy, you need to make your employees aware of what is the policy, what is expected of them. So if you have somebody who says, no, I will not be tested, or no, you can't take my temperature, what does your policy say about that? What's the repercussion of that? Social distancing, the same sort of thing of what is it that you're expecting of people? They have to stay 6 feet away? Okay, what if someone makes a mistake? Okay, well, what if someone makes the mistake 20 times in a day? How is it that you're dealing with that? What does your policy say about the distance itself? And then also any sort of violation of that policy, what is going to be the ramification of that violation? Teleworking, again, for some of you, that's going to be very new because nobody teleworked before. For others of you, that is going to be putting a policy in place that is kind of memorializing what you have already done over the past 8 to 10 weeks. How have you allowed people to work from home? How are you going to continue to allow people to work from home in the future? What's the expectation there? Also, when it comes to teleworking, please be cognizant of what your states say. There are some specific states, not surprisingly California, that have very specific rules about the sorts of reimbursements that employers have to offer to employees for expenses that the employee incurred in teleworking. If they had to buy a printer and a ream of paper, the employer has to repay them for that. So please be careful about that, as there are some state-specific issues that you really need to be cognizant of when putting that in place. Just really quickly, also, it's not on here, but I did want to touch quickly on company property. Some people picked up and left the office really fast and took a bunch of stuff with them so that they could effectively work from home. To the extent that people were taking things like monitors and computers and flash drives and those sorts of things. We're going to try to find out what all is out there. Have people let you know what they took home with them. Make sure that you start keeping a list of it. What kind of data do you have in people's homes? Have people actually been shredding things the way that they should while they're at home? All of that company property that kind of just, when the floodgates opened, it all went out. We're going to have to figure out what that was and try to get it back as much as possible. Or at least keep track of it at a minimum. Employment policy face coverings, you probably don't have a policy about that unless you are some sort of construction or manufacturing site. And then the FFCRA, that's the Families First Coronavirus Response Act. That is the legislation that provided the emergency sick leave and emergency FMLA. To the extent that people have not exhausted that, that's certainly a policy that you're going to want to put in place. Or as it pertains to the emergency FMLA, that's going to probably be a rider to your current FMLA policy. Employment policies you might have to revise: attendance. Some people still have no fault attendance policies. You need to be looking at that, particularly if you have some sort of staggered schedule. People are only allowed to come in on a rotation. How is that going to affect what your attendance demands are? Paid time off. I know some employers suspended their paid time off, the employee's ability to use paid time off during, furloughs, things like that. Are people allowed to use it now? Have they been accruing it? What's the situation there? Leave of absence, that, may go to something that Henry's going to talk to us about later, of the people who can't return to work. Can they take a leave of absence? Potentially. Travel. I mean, very few people are traveling right now, but as things start to restart, what's the travel policy going to be? What kind of authorization is needed to do that? And then again, coming back to discipline. Once you have those expectations set for your employees, what is going to happen if they don't meet the expectations? Always something that you need to communicate to your employees so that they are aware and there's no surprise about what happens if they don't follow a policy. So I'm going to wrap up by talking about training. I think training is a huge part of this. I know that there are some companies that are setting aside a week, multiple days at least, to training people before they come back to the workspace. So managers and supervisors, they've got to understand these policies once you get them in place. What is their responsibility for the policies? Who is going to answer questions about the policies when managers and supervisors simply don't have the answers, or it's a very specific question? And then you're also going to have to train your employees. Do they understand the policies? What are the expectations? Just a little caveat about training for our wage and hour minded people is that if you have non-exempt employees and you're making them go to training, and you're not currently paying them, you do have to pay them for training. Just keep that in mind. And then this is also a really great time to remind people what hasn't changed. Your training can also consist of, remember, no discrimination, no retaliation. To the extent that things had to be confidential before, they still need to be kept confidential now. And then performance. People, even though we're all working in this weird time, people are still expected to perform their jobs. And we still need to be keeping up on things like performance improvement plans and written warnings and things like that. Those are things that haven't changed that we really need to make sure that people are still keeping in place. And so with that, I'm going to turn it over to my good friend Sandy to talk about privacy concerns.
All right. Thanks, Carolyn. So let's move on to the next slide first. In this new world where you're reopening, you're going to be facing some new potential privacy hazards that could come from a variety of places. You may be considering using new tools or technologies to aid your effort to reopen safely. You may be collecting data from your employees that you've never collected before. And you may be wondering, well, what can we do with that data? What are we allowed to do? What do we need to do to comply with all the privacy laws that we know are out there? This is a list on this slide of just some things that different employers are considering, including getting test results from employees, giving them virus screening questionnaires, asking them to wear wristbands that vibrate if people get too close to each other, using contact tracing apps, distributing digital immunity badges to employees who have developed antibodies, and then also using infrared scanners in combination with facial recognition software to quickly scan groups of people to see if they have fevers as they enter and leave buildings. Also, people are going to be using thermometers, right? An old tool, but it's going to be used. So you're going to be gathering a lot of data, and you're going to want to think about both the effectiveness of these potential tools and all this technology, but also the privacy considerations that arise when you're collecting and using this data. So let's go to the next slide and start thinking those through. So on this slide, I've got a list of some of the key questions that everyone should address whenever they're considering implementing a new tool, a new technology, a new process to collect data, or they're collecting a new set of data, such as employee temperatures, right? These are the questions the basic questions that you're going to want to consider and answer for yourself. And I'll talk about specifically why you want this information in particular later as we go through the privacy laws that come up. But you're going to want to think through, what data are you collecting? You know, how sensitive is it? Is it health data? Is it biometric data? How specific is it? Do you have to have exact temperature readings, or can you get a person to just say they don't have a fever, right? How are you going to collect the data? You might think about the different ways that data is going to be flowing into the company in new ways and old. Are you going to understand all the devices that you might use to collect that data? How do they work? If you're getting them from a company that's selling you these devices, have you vetted that company and done your due diligence on that vendor? Then you want to think about how you're going to protect that data. If you're using a device, do you understand how it will protect the data? But if you're not, if you're just gathering data through written forms, for instance, what are you going to do with it once it's in your possession? Why are you collecting it? For what purpose are you collecting the data? Is it just to help protect your employees, your customers, your visitors from the spread of the virus? Does your company want to use this data for any other reason, such as helping to project the future financial health of the company, employee discipline purposes, insurance purposes? There may be a variety of different things that you might want to do with the data, and you need to think that through at the start. To whom will you disclose the data? Is it only going to be available to people in HR? Others in the company? What about vendors who are helping you collect and maintain the data? What about public health officials, first responders, the media, God forbid? Think about who you might disclose this data to. And then, how long are you going to keep it? You might not know exactly how long you plan to keep this data. You might not have a specific time frame in mind, but then you want to think about, well, what criteria are we going to use to determine when we will destroy this data? I recommend don't keep it forever. You want to set a retention schedule for this data to help reduce your risk going forward. And we can move on to the next slide. So my employment colleagues on this call have lots of acronyms. Carolyn talked about the alphabet soup. Well, privacy lawyers get acronyms too. And some of them overlap with what employment lawyers do. But here are some of the relevant laws that might come into play when you're collecting data about your employees as you go about reopening your businesses. Carolyn also already talked about some features of the ADA, the Americans with Disabilities Act, that protects qualified individuals with disabilities from employment discrimination. But it's really also a privacy law because it controls what an employer can collect from its employees and what the employer can do with that information once it's collected it. So as Carolyn mentioned, you cannot typically ask employees to undergo medical examinations or ask them questions about their disabilities unless those questions are job related and necessary for the conduct of your business. But here, where we're during this pandemic, you can ask them if they're experiencing flu-like symptoms. You can measure your employee's body temperature, and you can exclude individuals with disabilities, such as having COVID-19, from the workplace because they pose a direct threat. The EEOC has said that having the virus makes you a direct threat, so employers can exclude you from the workplace. The ADA also requires you to protect that data. You have to keep that information that you gather confidential and in a separate medical file. You only can disclose it outside the company in limited circumstances. You can disclose it to emergency and first aid personnel if the person might require emergency treatment. You can disclose it to supervisors and managers within the company if they need the information in order to understand restrictions on the person's abilities to work or their job duties or any information about reasonable accommodations. You can disclose it to government officials who are looking into your compliance with the ADA. And you can disclose it for certain insurance purposes. HIPAA, everybody always wonders, well, wait, what about HIPAA? I've heard of HIPAA before. I'm not a privacy lawyer, but I know HIPAA protects health information, right? Does HIPAA apply to me? Well, if you're an employer and you're not a health plan or a healthcare clearinghouse or a healthcare provider, HIPAA probably doesn't apply to you. Sometimes it can apply when you've got a self-insured health plan, but in these circumstances, for the majority of you, HIPAA is not going to apply. I just wanted to put it up there because people get worried about it when we're talking privacy laws. The GDPR, for those of you who haven't heard of that before, that's the General Data Protection Regulation. That is the EU regulation that protects the personal data relating to people who are in the European Union. If the GDPR applies to your company, and it might even if you don't have offices over there, for instance, if you're offering goods or services to people in Europe or you're tracking the behavior of people in Europe, then the GDPR can also apply to your employees who are over in the EU. Now, I want to mention the EU regulators. All of the member states in the EU have regulators that enforce the GDPR. They've all issued guidance about compliance with the GDPR during the pandemic. So for instance, Ireland's privacy regulator has addressed under the GDPR the legal basis for collecting health data during the pandemic. The UK's regulator has issued guidance for employers about workplace testing. So I would recommend seeking out that guidance if you have employees over in the EU and the GDPR applies to you. And lastly, BIPA. I put BIPA in there as it's short for the Illinois Biometric Information Privacy Act, but think of it as a placeholder for state laws. There are a variety of state privacy laws out there. BIPA is one of them. It requires companies that collect biometric information to give notice and get a consent from people when they're collecting that information. So we're talking about facial recognition information, fingerprints, not body temperature. BIPA can apply. Other states have biometric information protect privacy laws, like Texas and Washington, although they don't have a private right of action. BIPA does, so it typically scares employers a little bit more than the others. There are also state breach notification laws that can cover the breach of health data or medical data or other personal information. So if the information that you collect about your employees is subject to a breach, you'll want to pay attention to those state laws. And then last but not least, the CCPA, the California Consumer Privacy Act, a very expansive, fairly recent privacy law that protects the personal information of California residents, gives them rights to control their information even when it's in your hands. Right now, it does not apply to personal information relating to your own employees, but that exemption is going to expire on January 1, 2021. So next year, unless it's extended by the legislature. So the CCPA will come into force and impact your employee data to the extent you have residents of California. So faced with all these privacy laws and their various requirements, you might be a little overwhelmed. So I'm going to give you on the next couple of slides some very basic privacy compliance tools. that you can try to use to help minimize your company's risk of non-compliance. And these tools cut across all privacy laws around the world. And if you put them into place and you keep them in mind, they will help you comply, even if you're not going law by law, state by state, okay? So this first slide here are these basic privacy principles. These are actually laid out specifically in the GDPR, the EU's regulation. But even if the GDPR doesn't apply to you, you might still follow these principles to help reduce your risk. And very quickly, I'll just say that the different principles include lawfulness and transparency. So that's basically have a legitimate purpose for collecting data about people. Don't just collect the data for a purpose unrelated to the needs of your business. Tell people, transparency is telling people what you're collecting, why you're collecting it, how you're going to use it, how you will disclose it, how long you're going to keep it. The purpose limitation is the idea of only collecting personal information for specific purposes, and don't further use it for other incompatible purposes. Don't collect it for one purpose, tell people, well, that's what we're going to use it for, and then later on, when it's sitting around in your servers, oh wait, we've got a new idea to use this data for something else. Don't do that. Data minimization is the idea that you should only collect what you need to accomplish your purpose. For instance, if you want to know if someone who works for you has a fever, don't ask them for their complete medical history. You don't need that information there. Accuracy is the idea that when possible, you want to make sure your data is accurate and up to date, particularly if you're making decisions about people that's going to affect them. Make sure you've got the correct data. The storage limitation is basically, once you have data, only keep it for as long as you need it. Don't have it sitting around just waiting to be breached. That's just a risk, and you can reduce that risk by getting rid of the data. Integrity and confidentiality, that's the data security principle. Protect your data against unauthorized use or disclosure. Think about who's going to get access to your data, how you're going to prevent unauthorized people from getting access. Accountability and auditing, be able to demonstrate your compliance, right? Keep records, document what you've done. Pay attention to changes over time. Make sure you're maintaining your commitment to these principles and to privacy compliance. And we can go to the next slide. This is the second set of tools that I want to give you to help get your company up to speed on privacy compliance. It's basically, you take those privacy principles and you're putting them into practice through some work product. This is the stuff you're going to write and create and do. A data inventory is the idea that you can't comply with privacy laws if you do not know what data you are collecting and from whom and for what purpose. So those questions I listed a couple of slides back that ask what you should be considering when you're collecting information from employees. The answers to those questions go right into your data inventory. And then you're going to use those to build all the different pieces of your privacy compliance program. Privacy notices are the notices that you provide to people when you collect data about them or from them that explain what you're collecting, how you're going to use it, how long you're keeping it. That's to meet your transparency obligations, right? Using your data inventory, you're going to know who do we need to give privacy notices to and what do they need to say. Policies and procedures, those are your internal documents that control how the company collects and uses personal information. They explain who gets access to different data, what happens if someone asks for access, what happens if someone wants to exercise their privacy rights, and what happens if there's a breach. Those are your policies and procedures. Your contracts are going to be with third parties who might get access to your personal information that you've collected. A lot of times it's with your vendors that are helping you collect or store or manage that data. And you'll want to make sure that those contracts include provisions that limit what the vendors can do with the data and how they must protect the data. Policies and procedures are no good if they're written down and put in a drawer. So once you've got them and got them ready to go, train your employees, train your workforce on them so that they can follow the rules that you've set out. And finally, audits. Make sure you're checking to see if your policies and procedures are being followed. Take steps to close any gaps in compliance. Are you properly documenting your compliance? These are the different pieces of work product that you're going to consider. And using the privacy principles that I laid out as your guide and covering all your bases with this work product, you're going to reduce your company's risk of non-compliance with the privacy laws. And with that, I'll turn it over to Henry to take us further into this.
Thanks, Sandy. I'm told we're running a little behind here, so I'm going to pull out my inner New Yorker and speak really fast. If I'm going too fast, somebody yell. I'm going to be talking about resisting the return to work. And what we're really talking about is going back from a telecommuting or a furlough situation back to active work in the workplace. And we put together a slide here that has a lot of the common responses that we've gotten so far from our clients are telling us that their employees are saying, you know, despite what you see on TV about everybody wanting to get back to work and getting out, people like to go to a restaurant. They don't really want to go to the office. So there's a lot of excuses that people are coming up with, some legitimate and some not. And we got some responses here, and these basically fall into 4 or 5 different categories. The main one is fear. It's fear. The other ones are, you know, health related, unemployment, financial related, and family issues, which, you know, a lot of them, those are interlapping kind of ideas. Now, but fear is something that I want to talk about a little bit. As an employer, you really need to understand the reason for the fear. You know, you have to dig a little. You got to figure out, is the employee fearful of returning because of a disability? Because if they are, then you're going to have to engage in the interactive process and see if there's a, you know, if there's a way that this employee can perform the essential functions of the job without coming into work. And if the answer to that question is yes, it's because of a disability, they have an underlying condition, they have, you know, a suppressed immune system for whatever reason, and you can determine that that employee can actually continue to perform the essential functions of their job from home, where they may have been doing that for the last 2 months, then it's kind of a no-brainer. And allowing that employee to work from home is a reasonable accommodation. And as far as the other topics, we're going to talk about them a little more, but just one quick point. It's one thing if an individual raises a concern or a complaint, whether it's safety related, it's too dangerous, or you know, or whatever reason. It's another thing if a group of employees raise it, and as employers, you should always be aware of the possibility of what we call concerted protected activity. If you got a group of employees saying that it's unsafe to go into the workplace, you know, and you turn around and fire them all, you know, you're going to have big problems under the National Labor Relations Act. So if we go to just the next slide here, I'd like to talk about some of the medical issues that are reflected in this idea. General overriding principle, an employer doesn't have an obligation to just offer up a reasonable accommodation unless it's in something that's obvious the person might need. So if an employee has some underlying condition that you know about or you don't know about, it's not up to the employer to raise it. The employee has to ask for the accommodation to start the process going. A key point, as an employer, you cannot bar an employee just because they're at a higher risk to develop the disease. That includes older workers, that includes people with heart conditions or diabetes. We've all heard what the different classifications are, but you can't just bring it up. Now, you can stop somebody from coming in if they're a direct threat to others. If they have symptoms, they're going to get other people sick. Clearly, you can. Technically, you can stop it if the person would be a direct threat to themselves. But that's a really, really tough standard. And you should be super sure that you know what you're talking about. If somebody is, you know, came back from, you know, a leukemia treatment, and you know that they have a suppressed immune system, and you're putting them on a line where they're like 2 feet from everybody else. No. But get a doctor's opinion before you do that. Get an analysis. You want to make sure you're on solid ground before you start discriminating against people because of their underlying disabilities. Follow, you know, when we're talking about the employee's own medical issues, you're going to follow your normal reasonable accommodation procedures. You know, you find out what they have, what you need, how you can help, engage in the interactive process. It works. Just one last point here is the idea about other people. What a lot of people have said is, well, I don't want to go back because I have a spouse or a family member who is could be compromised, and we don't want to. An employer does not have an obligation. You know, technically that person would be like what they call associational disability. So if you're you can't discriminate against somebody because they're married to somebody who has a disability. But on the other hand, you don't have to provide an accommodation either. It may be good employee relations. It may be a good thing to do in general. It may be something that can easily be handled, but you don't have an obligation to reasonably accommodate a request from somebody because they have somebody else in their family who is at risk. You can go to the next slide. All the accommodations are, you know, what they've always been. You know, one of the main ones that pop up here is just allowing people to telework. It seems to have worked so far for a lot of people. For some people, it doesn't, but for a lot of companies, it's working fine. You could install physical barriers, you know, plexiglass between workers, that sort of thing. Temporary job restructuring. You know, in some cases, an unpaid leave of absence could be a reasonable accommodation. You know, in some places, especially California, you know, you're required to consider that. You can do alternative work schedules. You can engage in extra social distancing procedures. Next slide, please. Medical issues. One that keeps coming up is the masks, and there's different variants of that. Is I don't want to wear a mask. I don't like the way I look at a mask. A mask is uncomfortable. That's one category. And then there's the other side of it, which is I can't wear a mask. I'm physically unable to wear a mask. I have problem breathing when I wear a mask. I'm allergic to the materials in the mask. You know, there's a whole host of things that go by. There's, you know, again, you could look to some of those local orders that Carolyn was talking about. A lot of them require masks in certain situations, but they also provide that certain people don't have to wear them. Notably, on a lot of times, it's people with developmental disabilities or autism or hearing problems, that sort of thing, or breathing problems. They're specifically excluded. But if you can find a way to work around it, you can do it. There's lots of other safety measures. There's lots of accommodations that could be made, different kinds of gloves or face masks, gowns, face shields, that sort of thing. There's lots of organizations out there that can help you figure this out, and we can help you find them if you need to. Next slide, please. Just for CLE reporting, the code is pound 931261, or for the millennials out there, hashtag 931261. That's 931261 is your CLE reporting code. Again, family members' medical issues is part of the resistance to coming back. You got to determine whether there may be, aside from the ADA, you got to determine if there's FMLA available or leave under the FFCRA or state law leaves. Again, there's no requirement to accommodate a person because of a associational disability, but you got to be aware of discrimination claims. So if you're letting some people work from home for whatever reason, but not those with, you know, a significant other who's sick at home, you're going to have sorry about that. You're going to have a discrimination claim. Next slide, please. People are resistant about unemployment because they're coming back and saying, hey, I'm making more money on unemployment. I don't want to come back. The number one rule that we've been telling people over and over again is, as an employer, do not offer any advice regarding unemployment compensation. Just don't. One way or another. I mean, you can tell the employees that it may affect their ability to receive unemployment benefits, but don't say one way or the other. It's not your decision to make, and you don't want to influence the decision. You just tell them. You should also know that there's a nice little quote here from the DOL Employment and Training Administration website about, if you quit work without good cause in order to get unemployment, that's fraud. So be careful, and you don't want to be aiding and abetting fraud. Next slide, please. Along those lines, employees are now, if they're on unemployment in a lot of states, are being required to certify that they're actually able to work and actually available to work. So many of the states and people, not all of them, but a lot of them are now requiring the employers to certify that and affirmatively report that if the employee is available to work and they offered them work and the individual refused, you have to report it, in which case the person's going to be taken off unemployment. Next slide, please. Again, people raise childcare issues. My kids are home. I got nobody to watch them. There's the FFCRA, the Emergency Family Leave Act under there. You should think about paid time off, whether they can continue to telework, unpaid leaves of absence, and whether the state leave benefits or laws that impact this. For example, in California, there's a Labor Code 230.8 entitles employees to take up to 40 hours each year to deal with school-related issues, which include if your school is closed due to an emergency. This qualifies as an emergency. So if there's no school, you can get up to 40 hours of leave. And that's separate and apart from what you may be available under paid sick leave or the Emergency Family Leave Act or anything like that. Next slide. Traveling issues. This is actually one of the biggest problems that we've heard, is that a lot of employees, with some justification, are very hesitant to go on public transportation. They don't want to get on the subways. They don't want to get on the buses. They don't want to get on the metro. So what you can do is you can try to alleviate the fears by providing information to the employees about what the local transit systems are doing. You can offer to pay for your employees parking or give them a discount. You can arrange for employee carpooling, or you could provide a shuttle. But at the end of the day, if they have to come in and they don't, then you have to have one of those policies that Carolyn was talking about earlier to address how you're going to deal with that. And I think our time is just about up. So we had hoped for some questions. I'm not sure if we have time to respond to any now, or anybody.
So I think we're going to ask if anyone has any questions, just to send us an email. We'll be happy to answer them and discuss them with you. But since we're about out of time, I'm just going to say that everyone who attended will receive an email after this program ends, which will include a link to provide the necessary CLE information for us to do the processing of it. And it will give you access to the webinar slides and a recording of the webinar. And finally, if you have not already done so, please be sure to register for the next webinar in our weekly series, which is going to be contract considerations regarding force majeure in the COVID-19 era, which is scheduled for next Wednesday, June 3rd at 1 p.m. Eastern. Thank you, everybody, for joining us. Thank you to my co-presenters for their wonderful job. Thank you to our marketing team for putting this together. And I hope everybody stays safe and keeps everyone safe as the return to work begins. Good luck. Bye.
Thank you all.